Thank you very much, Jaroslav. Thank you for coming in this morning, and good morning, everybody. So this morning, together with Kai, in fact, we will be developing the means that you can listen to or actively develop before judges, and its enforcement at national level of state aid. And in fact, as you see in the outline, I will divide my presentation into two main parts. The first is in fact, what we can call public enforcement or EU enforcement, which is what the Commission should do in terms of recovery, because we have a presentation here on focusing on recovery of unlawful and incompatible or unlawful aid. I will come back to that. And Kai will focus his presentation on damages action before national courts. So there is part where the Commission is using its own powers, and it can derive into actions by the member state in particular against beneficiaries in order to recover unlawful aid, which is the purpose of this EU enforcement. And we'll come back to the recovery process by the EU level, by the Commission, because it has an impact at the national level. Then what we call sometimes private enforcement, in fact, it is national enforcement, twofold, national enforcement by the state, which is public enforcement at national level, when the state is trying to recover unlawful and incompatible aid following a decision of the Commission in most of the cases, and pure private enforcement at national level, which is the competitors suing the state or the beneficiaries, or sometimes the beneficiaries trying to sue the state. This is the national enforcement, the second part of the presentation. And of course, I refer to the presentation of Hans-Peter and Niels on Wednesday morning, which gave you a broader view of all the principles. I will not repeat that, and we can refer to his presentation. And the main sources, you have seen the main sources with him as well. I will not repeat them. You have here listed the most important sources that you need to have, notably as a judge or a pleading person before a judge, pleading a case before national court. And I will come back to that, but here we are in a situation when we have an issue of state aid before a national judge, which should be only when we have a situation of an aid which is unlawful. Unlawful means an aid which was not notified, which should have been, or was notified but implemented before being approved by the Commission. If it is a standalone action, then the Commission is not involved. The judge is complying with his duties and is hearing the case, and the judge should have, as bad reading, in fact, all those cases, all those documents, which is mainly the Article 108.3 of the treaty, which is the seat of the powers and the duties of the national court. Then you have the Council regulation, which is a procedural regulation, which mainly applies to what the Commission does and not, in fact, what the national court do, but we will come back to that difference. And the two most important documents that a judge should have read, digested, and have always in its library is the recovery notice, which is a soft law document, which is an interpretative document, communication by the Commission, which synthesizes and explains the case law of the Court of Justice for recovery issues, which is a new recovery notice since July 2019, replacing the first one which existed in 2007. And then the enforcement notice, which regroups all the powers and duties of national courts, cooperation with the Commission, notably, but not only, what the courts, the national court, should do in a case confronted with state aid, which is an enforcement notice of 2009, but which is being replaced this year a new text, draft text, was submitted to consultation a few days ago by the Commission in January, and is open to consultation until mid-April, and will be, unfortunately, most of the time adopted as is, because the consultation does not influence much the text, unfortunately, by experience, but this notice will be the source of the new information source for the national judges. And then I will come back to that later, but you have the links to various studies which can show you, to most of you who are judges, I mean, I've seen that 25 of you are judges, most of you should refer to that documentation that you have in free access on internet through the website of the Commission, DigiComp. You have first the latest study on the enforcement of stated rules and classification per member state with country reports of what the national court do and do well or do not know well. 2019, you have an online database. You have the basic first study on that, to which I contributed in 2006, and an update in 2009. You have a book, in fact, which is of more than 800 pages, available on the site of the Commission with those links. And you have also a summary of 80 exemplary judgments, which I wrote for the Commission in 2006-07, which have not been updated since, and there is a 10-year gap, in fact, which is the National Court judgment, which is the national pages of EU stated law, national pages, National Court judgment on state aid, which are summarized, which is a sort of selection of good judgment and exemplars of good judgment by national courts. So you can inspire from that. These are the main sources that you should refer to for the specific issues that we will be discussing now on recovery issues. A pause quickly on the main lessons which can be drawn from the 2019 enforcement study, which confirms the progressive increase of the level of number of cases, but the prevalence of private enforcement over public enforcement, which means that there are more cases before national courts initiated by private players, competitors in particular, sometimes beneficiaries contesting recovery orders, than action by the state wanting to execute and enforce a Commission decision, for instance, which is possible. To be noted, 3 member states, which may still be the case, I'm not sure for the last 2 years, Luxembourg, Croatia, and Bulgaria, where there is no case initiated by competitors, which is strange and unfortunate, but we cannot do anything. At least the judges cannot do anything against that, but I hope there will be welcoming cases because there are issues. And in those other member states, there are no public enforcement by the state before judges. Now, the cases are spread over most member states and no longer restricted to a limited group of member states, as it was 20 years or 10 years ago. But there are still a fragmentation of procedure. As you see, recovery is the most recurrent actions, and damages, which Kai will explain, are very rarely sought again and granted. There are some cases granted in France, and in fact in Italy now, with the Supreme Court recently, I will mention that. So there are a handful of cases in over the EU for the last 60 years, which is strange, but which may be explained by the difficulty to prove the causal link, notably, and the level of amount of damages, and also the lack of knowledge, the lack of courage, maybe by complainant, to go against the member state in particular, because sometimes they are involved with the member state for future public procedure, etc., etc. So, but paradoxically, most of the cases are in France, which is in fact the state where the state is the king, where the state is inaccessible, and we know that the French like kingdom more than others, although they kill him. But in France, the state is nearly difficult to challenge and attack. But in fact, in state aid, there are good examples of situations where the state took so extreme decisions, extreme bad-faith decision, in fact, that it was sued by beneficiaries, in fact, and competitors, and was condemned to pay damages. And the last, there is a sort of a trend in certain member states to adopt specific legislations on procedure, on ad hoc legislation to cover and harmonize recovery issues. In Belgium, it's only for ad hoc global recovery, but we have seen in Netherlands, in Spain, etc., some ad hoc recovery legislation which harmonize the situation for recovery, which is an issue. So let's turn, but I will skip some slides. Don't be afraid of the number of slides. We'll skip a bit some slides, but I kept for you most of the documentation. Let's go through the public enforcement. So what is the situation where the Commission orders a recovery? You should have a final decision, which by definition should have a finding of unlawful and incompatible. Unlawful means that the aid was not notified or was implemented before the authorization, and the Commission found that on the merits of the case, the aid was incompatible, so not likely to be exempted. Then, since the procedural regulation, in fact, since 1999, regulation was modified and recasted in 2015, the Commission has the obligation to order recovery. If it found that an aid was unlawfully granted and is incompatible, it has no faculty and no discretionary power, as it was in the past, before 1999. It has to recover and order recovery by the member state. Two exceptions, and this is now in Article 16 regulation. Two exceptions: if there is a statutory limitation, 10 years from enjoyment of the aid, that's for the power of the Commission against the member state. We will come back to that. And if there is a general principle of law which is violated, mainly legitimate expectation, which is exceptional because member states should not have, in fact, like beneficiaries, legitimate expectation, because they should know the law, they should have seen the law, and they should have abided by the law. But it's only in situations where the Commission or the EU institutions have constructed a legitimate expectation by their behavior, which is very rare. And then the objective of the recovery is to re-establish ex-ante situation, non-distorted competition. It is not a sanction, which means that it's not a fine or the recovery. It's just to pay back what you should not have received. So it's not at all a fine. And of course, it's not disproportionate. As much as you have received, you should just pay back. And the state and the judge, as a member of the state, is obliged to issue that recovery order, here as an enforcement by the Commission. And they should be interest rate, compound interest since 2003, in fact, which is in order to repair and have a full integral recovery of the distorted competition. You have to pay back the economic advantage that you benefited from the aid, unlawful aid, for a certain time. The recovery policy is systematic by the Commission in all cases. There is, in fact, no means of defense. Nobody can defend against a recovery order. People are trying, and they've been trying, and they will continue to try. But there is only one means of defense which could be and have been accepted by the Court of Justice, which is the absolute impossibility. You have to show that in practice, and you have done everything possible, that you have been of good faith with the Commission, that the state cooperated with the Commission and tried to find a solution, but it was impossible in practice. For instance, disappearance of the tax documents in order to show exactly the tax issues for a long time. Things like that have been accepted by the court in this Commission versus France case, for instance, and you have recent examples which reject these issues. You can refer to that. There is a political context of a negative decision. You have, in fact, an infringement of the law by the state, which is that an unlawful aid and incompatible aid is a violation by the state of the law, which is similar to a cartel. So I assimilate a state violating the law in state aid to a cartelist for antitrust law. And unfortunately, they are not treated the same, as you will be seeing. They should have been treated the same, but the treaty is protecting the member state, as we know. So the member state has not notified yet, and it should have done. If there had been some doubt, it should have notified. And for political reasons, as we know, they don't dare to notify in most of the cases because politics is more powerful than law. Judges are there to sanction this violation. And the problem is that the grantor of the aid, the violator of the law, is in fact the one who will repair the violation. So that's a bit difficult, and there is a conflict of interest. And the beneficiary is in fact a third party, is the actual victim of all that and cannot protect himself much, but should have protected himself and should have seen the law better than the state. And as you will see at the end of the presentation, in most of the cases, the victims, the beneficiaries, should have avoided probably the hard consequence if they have not accepted illegal and unlawful aid, which is possible, or educated the member state in order to anticipate the issues. And the reason why there is no legitimate expectation of beneficiaries, he's deemed to have known and perfectly known the law even better than the state. The law, in fact, is quite clear, except in most of the situations where they are disputed, is the notion of state aid. Sometimes it's difficult to know if there is an aid or not. Then the judge should decide on that in competence, in full competition with the commission. And if there is any doubt, they should refer the matter to the Court of Justice. So this is a summary of what you know, but it's very important to remind ourselves about that division. It's distinct but complementary roles. On the left, what the Commission can do and should do. So there is obligation to recover, as you have seen, and you see the scope of its competence limited to those articles. And on the right, national codes, which is limited, competence limited to unlawful aid. If you have an aid which is not unlawful, well, you are not competent because there is no violation of the rules that the states should safeguard, i.e. the violation of 108.3 only. So you should decide that there is an aid. You should safeguard individual rights in case of unlawful aid by setting aside all national law which would prevent you from safeguarding those rights. And you should enforce the negative decision, which is a title, a right, legal title to enforce the law as a decision at national level. And the interaction is at the notion of aid, of course, where there is an issue. National Court is still competent if there is an ongoing procedure before the Commission. So you cannot stay proceedings. We'll come back to that. You can ask questions to the Commission, but you can ask, of course, or should ask in certain situations, refer questions to the Court of Justice. And you can use the Commission as an amicus curiae as well. It's this Article 29 of a regulation procedure where you can refer questions to the Commission, or you can invite or authorize the Commission to come and to submit observations before you. And you can accept that the Commission comes before you to plead orally the case as an intervener before you. So that's used more and more, but you should consider to use the Commission more and more. We can discuss that in Q&A, but because in practice it's a bit difficult sometimes, you should treat the Commission as an intervener according to your judicial review procedure. But of course, reopen the case and respect the contradictory principle and have the parties able to contradict or discuss what the Commission will say, because you can see that the Commission, when they appear before National Court, they are a bit aggressive, i.e. They know the law, they pretend to know better the law than others, and they can influence you a lot. Rightly so, most of the cases, but sometimes they can make mistakes, as everybody, and the judge should keep things very well in good order when the Commission is before it. So this is a schematic presentation. Is there a measure which is a state aid? If there is no state aid, you are not competent, of course, or if the state aid is an existing aid, i.e. an aid which had been declared compatible, or an aid which is protected by legitimate expectation, by statutory limitation for many years, then you are not competent, because this is the remit of the Commission only, and the National Court is only competent for judging new aid, i.e. aid which are created new and unlawful, i.e. Not notified to the Commission and not approved. So that's a basic dichotomy, which is very important. Then you should check if the aid has been notified. If the aid has been notified, it's on the left. There is no issues. There is a normal implementation, but you should be aware of the time limits challenging a decision of the Commission. The aid had been declared compatible. The decision of the Commission can be challenged within 2 months plus 10 days plus the time of publication. So it may be 3 months or more from the publication of the decision, which means that during that time, until the decision is definitive, the decision can be challenged before the Court of Justice, before the General Court, and then can be annulled. And if the decision is annulled, it is with retroactive effect, which means that as long as the decision is not annulled, can be annulled, the case can come back to you if the decision is annulled, because then at that time the state aid becomes, with retroactive effect, unlawful, because deemed to have never been approved if the decision of the Commission is annulled. So it's a case where cases can come back to the judge, and the beneficiary should be aware of the risk to accept and use an aid which is being challenged by third parties. But National Code, you can do nothing against that for the time being. The aid is lawful until it is the approval is annulled. And then quickly, if the aid has not been notified, then you have an unlawful aid. Then you have the situation, the dichotomy between a full recovery and partial recovery. If the aid was not notified and fully implemented, indeed, it's unlawful. And if you decide why the Commission has not approved yet the aid, then you have a full recovery. You are obliged to fully recover the aid. If you are deciding as a judge before the Commission, after the Commission has decided that the aid is compatible but was unlawful, i.e. the aid was lately notified or was implemented before being notified but was lately declared compatible by the Commission, then if you as a judge, or you are seized of this situation but you are deciding after the compatibility assessment by the Commission, it's a problem of timing, then you are bound by the fact that the decision of the Commission declared the aid compatible. Then the recovery of the aid for the past will be limited to the unlawful interest, i.e. you will have to pay back only the economic interest of the fact that the aid was paid in anticipation of the compatibility declaration by the Commission. This is the difference of the timing. If you decide whilst the Commission has never declared the aid compatible, then it's a full recovery because it's unlawful. The aid was unlawfully granted, and there is no interference by the Commission. And on the contrary, if the Commission has declared the aid compatible whilst you are deciding on the fact that the aid was unlawful before the decision of the Commission, then your recovery will be limited to the economic interest of the past, which is the unlawful interest only, but not the capital of the aid. So we can discuss that on Q&As. I'll accelerate a bit now, just to show you the difference on 2 points. The statutory limitation. The statutory limitation is provided by Article 17 of the regulation, and which is a rule which applies to the Commission. It is not a rule which applies to the judges. Full stop. It's the code said that clearly in cases. Estipaga, you've seen that with Mr. Neil and Nelson Antonius. It regulates only the relationship between the Commission and the Member State. So the statutory limitation before you, which applies, is only your own national statutory limitation, provided it is not too short, provided it's compatible with the principle of equivalence and effectiveness, etc. But you will the recovery before you will be governed by national rules and not the regulation, which applies to the Commission only. And the most important article for you in the regulation is Article 16, paragraph 3, which says that you should recover immediately without delay, which means you don't wait for the Commission if the Commission is still investigating the case. And provided that, which is the most important words, provided you follow the national law, provided that the national law allows the immediate and effective execution of the decision, the recovery. And you should take all necessary steps to recover, which means that you should set aside any national law which will be an obstacle. Come back to that later. I will skip that. You will see there are some comments here about the need for clarity of the Commission decisions. This has been fixed progressively, notably by notices which change a bit the policy of the Commission. Here you have issues about conflict of interest and the spread over of powers between responsible authorities and timing, length of administrative procedure. The remedies have been fixed more or less in the recovery notice. I will skip that. And you see that there are remedies taken at national level with detection advice, or some national authorities which are empowered to implement national rules, stated rules. And then here, to mention here the fact to avoid for judges stay of national proceedings. If there is a challenge of the decision, so the decision is being challenged, but not suspended, i.e. the execution of the decision is not suspended, then the decision is fully applicable to you and you cannot stay the proceedings. You have to execute the decision and recover the aid sought by the decision, even though that decision is being challenged before the court of justice, the general court, because the aid, the decision is legal, presumed legal until it is handled. So you can do nothing there. You cannot stay proceedings, and you have to execute it immediately. If the decision is challenged, in fact, implicitly, indirectly, i.e. the recovery order, the national recovery order is challenged before you, which is in fact the result of the decision, you cannot either stay proceedings by waiting the result of the challenge of the decision, which is the basis, the legal basis of the national recovery order, because there is no suspension of that execution. You can refer a premier ruling to the Court of Justice on the validity of the decision, possibly, if you are the initiator autonomously of that reference, you can do that in all situations, which is a case mentioned by the Court of Justice after Georg Marion Uter, which is there, which is the Casa di Risparmio di Firenze, a case in 2006. I've not put the reference there, but which mentioned that if the national judge decides with its own motion to refer the case of the validity of the decision to the Court of Justice, it will be admissible. But if the beneficiary or the contestant, etc., are referring and raising this issue, the premier ruling is not admissible to the Court of Justice if those parties could have manifestly been admissible to challenge the legal basis, i.e. the Commission decision. So this is a bit difficult to understand because it's a paradox. In fact, the Court of Justice created the primacy of the action for annulment on the premier ruling, whilst the treaty did not provide that. But the Court of Justice wanted to focus on the possibility to challenge the decision directly. And if the beneficiary or the competitors could challenge that decision directly before the Court of Justice, the Joint Court, they should do it. And if they're not done it, they are barred from the possibility to refer that validity before you. So I would advise you, maybe if you want to contest yourself a decision of the Commission indirectly and consider that it is invalid, to show to the Court of Justice that you do that on your own motion and that your decision is not influenced by national court, national parties. So I skip some slides here about the immediate recovery. You will see these are examples of situations where the national court is obliged to set aside a national law which prevented, which precluded him from applying the recovery. You will see that. I will skip that. And here I will skip that as well. It's issues of who should be obliged to reimburse, since the Seleco case, which was an Italian case, which was a fraud, in fact, by Italian authorities, which emptied the company who should have reimbursed the aid, and they say, oh, I cannot reimburse because the decision, the beneficiary is emptied and is there is no longer any asset to pay back the aid. The Commission condemned this in principle, but the Commission should have verified the market price, and there is some dispute between the banks and the German versus Commission case, but I'll skip that to be quick. And the basic principle is notably confirmed in this Electrabel case, where in fact the market price decides if the buyer of a beneficiary receiving an unlawful aid should repay back the aid or not. So it will be the buyer will have to pay if there is a continuity, economic continuity between the beneficiary and the buyer, which is in fact, these are examples of the Commission decision practice about that. It is not old, because we see that there is still the Italia case, which is still being before the Commission, and a new case. Basically, the principles are those. Here you have the references of the economic continuity cases, judgment of the court and decision of the Commission. And I go directly to the principles. You have 5 principles to check in order to see who will be the entity to pay back the unlawful aid. And it will be the economic continuity principle. You should check the purpose of the transfer. Has the transfer been made in a purpose to in the scope of the purpose is to continue the workforce, so it's the same business model, and you have the same assets and liabilities in the new company, then you have a continuity. If the transfer price is not a market price, it's another element. If the shareholders are the same, if the moment of the transfer was carried out in order to avoid or to anticipate a recovery order by the Commission, and if there is no economic logic to the transaction. In all those situations, it's a bundle of indicia. You can decide, the court, national court, that there is an economic continuity, and then that the buyer of a beneficiary should pay back the aid because the buyer is in fact the beneficiary according to those principles. And you can refer also that to the Commission. You see that in Cernam and Val-Saint-Lambert, the Commission has invented a sui generis decision. They can, if you are a judge deciding about a bankruptcy of a situation, and you have a buyer of the assets of the beneficiary who receive aid in the past which were illegal because not notified, not approved, then you can refer the matter to the Commission to decide immediately, specifically for you, to decide is the buyer in economic continuity or not. And the Commission will take a decision, which is a definitive decision, but limited to that decision, is the buyer in continuity or not. It can help you to do that, which is the sui generis decision there. You have references there. Conscious of time, I finish off the public enforcement quickly now by the fact that the Commission can sue member states before decide immediately and sue member state before the Court of Justice and have sanctions, pecuniary sanctions, if the member state does not abide by the decision and the case, the decision of the Court of Justice. And the sanctions against the beneficiary may be the fact that the Commission can play the Degendorf principle, which is a principle of blackmail, so to speak, whereby the Commission will say to a member state, I will not declare compatible the new aid you notified vis-à-vis that beneficiary as long as you have not recovered other unlawful aid of that beneficiary. And action by competitors can be also an insight requesting reimbursement for beneficiaries. So let's turn to quickly to national enforcement, which can be public or private, depending on the member state or the competitors or beneficiary being the complainant. This is the basic case, and everything has been said by that case, which is competition between international carriers and La Poste in the past. And here, the Court of Justice divided the roles between the Commission and national codes, as you know. And you see other principles in the SFEI case, the principle that the judge should not stay proceedings if the Commission is still reviewing the case, immediate action, interim relief if it's possible. You should qualify the aid and refer the matter to the Court of Justice if you want or if you should. And you are obliged to recover except if there is exceptional circumstances, and you should grant damages if it is necessary to repair the situation, and the beneficiary is liable of an unfair competition act under national law if it accepts unlawful aid. These are the principles that you have seen already. It's the Article 108.3, which is the legal basis for you to act to safeguard the rights of the third parties. And you have the primacy of EU law over national law. You are obliged to apply EU law, even if necessary, by setting aside your own national law. So basically, you have to violate your national law if this violation of national law is necessary to recover an unlawful aid. There is no limit. There is no limit to your obligation. If you are tempted to respect a national law which prevents you from recover an unlawful aid, you are violating EU law, and you should not do so. So there is no limit, as we will be seeing. there are issues where even the res judicata principle will not apply to you. Here you have the trilogy of the most important cases, which shows that you have an immediate response, SFEI case, the self case, and the Dutch Lufthansa case, whereby you have three principles. You should not stay proceedings. You should rule yourself on the notion of state aid, even though the Commission is seized of that questions in a complaint, but they have not decided yet. However, which is Dutch Lufthansa, if the Commission has already initiated the formal investigation procedure by qualifying the measure as a state aid, provisionally, even provisionally, but the Commission has decided that there was prima facie aid and there is a formal investigation procedure, so it's not definitive, but still, at that time, the judge, you are bound by the qualification of aid by the Commission. You cannot say that there is no aid, for instance. You can refer the case. Yes.
Jacques, excuse me. Can we slowly come to a finish, please, so
yes,
that we have some time for questions?
But I really have to go through some principles, but I will do that in 2 minutes. And then in that situation, you are bound by the decision of the Commission. And it's only if the formal investigation concerns the qualification of aid, then you should not stay, and you can decide on your own motion and decide that there is an aid or there is no aid. So I will select the slides that are important to me. I mentioned this self case. You have all those powers to recover an aid, and locus standi, not only the competitors can act before you, also an operator which is not in a competition link with the beneficiary can act. Any person affected by the distortion competition, notably a person who should pay a tax which is used to finance a state aid to a beneficiary, but there is no connection between the beneficiary and the competitor and the third party. That third party has locus standi before you. Another case, Scott, is a case where you have the power to challenge and to decide that a recovery order is null if there is an issue in national law, but you have to be careful. You have to avoid that following this annulment, the beneficiary will get back the money. So the court said that you have to find a way that the recovery order should be taken again by the administration. That's difficult to implement in practice. That's the Scott 3 case. Then I skip that, and I skip those two cases. Res judicata, Lucchini and Closer-Holtz cases are simply cases which says that you have to set aside the national principle, which is the definitive decision. If you have a definitive decision of a court of appeal or a Supreme Court, and that there is the fact that the right to unlawful aid has been by mistake decided by judges at national level, this will not bind you. You have to set aside those judgments, definitive judgments, if those judgments prevent you from respecting the law and a decision of the Commission. So a decision of the Commission, definitive, is more powerful than a judgment of the court at national level. That's the meaning of those cases. And who can initiate the state aid action? The competitor against the beneficiary of the state, the beneficiary of the aid against the state, or the state to recover. And in fact, this slide summarizes everything. The beneficiary can sue the member state in certain exceptional situation, but it should not allow to escape recovery. Damages, yes, but if the damages are different in nature than the recovery, member state should enforce recovery. Competitors can sue the member state for damages or to have recovery from beneficiary, and they can sue the beneficiary as well for damages or to obtain recovery of an aid. And these are the reference of the cases. We can discuss that in the Q&A. And I finished there. You will have examples here of cases, and including cases of damages that Kai will explain in the case study, where notably you have a recent case in the Cour de Cassation in Italy, where there are 2 million damages, for instance, which have been granted against the state. That's for the competitor. Well, I finish off there. Sorry, I would have liked to have 10 minutes more, but we can discuss in the Q&A any issues on those slides before the presentation of Kai. Thank you.